Hello, hello, everybody. Sorry for the no notice. Jax West from Stephen Avery Project, MAM Gossip, Justice with Jax. My husband and I went grocery shopping because here in Chicagoland, we got a bunch of snow and now it's going to be really cold. And so it's like, all right, I'm just going to be in for the next 4 days. So let's go get some food. Got some food. He and I went downstairs to watch TV. Actually, funny thing, when we got home, our dogs were on the porch. And I had said to my husband before that our German Shepherd, I've seen her open the door. And now that they were on the porch, I'm like, see, Kai opened the door. So then he went through our video cameras and looked it up and saw that it wasn't the German Shepherd, it was our pit bull, Mallory. Um, so that was kind of funny. Uh, um, so we were sitting down, going to watch something. He was going over that on the camera, and then I got the email from Kathleen with the filing. So it's like, all right, go upstairs, start my computer, and let's go. So I have not read this. I don't know what's in it. Hello, Carrie. So it was filed today at the Court of Appeals. It is 57 pages long. It still lists the Honorable Angela W. Suckowitz, presiding judge. Doesn't list the new judge. Table of contents. Not going to read through the table of contents. Table of authorities. Not going to read through that. Scrolling, and now here's Wisconsin statutes. Okay, so page 6 of 57. Issues presented. 1. Whether this court must conduct a de novo review of the sufficiency of Mr. Avery's motion for post conviction relief on its face because of the circuit court's failure to conduct any such analysis as a matter of law. The circuit court answered no. 2. Whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State versus Edmonds and Brady versus Maryland. The circuit court answered no. 3. Whether the circuit court erred when it did not correctly apply State versus Denny to Mr. Avery's potential third party suspect evidence. The circuit court answered no. Statement of oral argument and publication. Pursuant to Wisconsin statute, blah, blah. I know some people get so upset when I do blah, blah, but I'm not going to read you the numbers of a statute. If you care that much, get this and read it all for yourself. Appellant requests oral argument to facilitate review of the complex legal issues raised herein. A publication is warranted because the case is of interest to the public. Page 7 is introduction. When dealing with stakes as high as a defendant's liberty, third-party perpetrator evidence walks a bit of a tightrope. State versus Mull, blah, 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 a bunch of numbers. Without regard for Mr. Avery's liberty, even after he has brought forth strong new evidence connecting a third party to Ms. Halbach's murder, the circuit court has denied Mr. Avery the opportunity for an evidentiary hearing. Mr. Avery now appeals the circuit court's denial of his amended third post-conviction motion because the circuit court's opinion is so legally and factually flawed that it does not even consider whether Mr. Avery has alleged sufficient facts to warrant an evidentiary hearing. Instead, the circuit court erroneously interprets State versus Denny as requiring conclusive proof of motive to satisfy the materiality requirement of State versus Edmonds, and as requiring the alleged third-party suspect to have the necessary skills to manipulate evidence in a manner that would implicate the defendant to satisfy the opportunity prong of Denny. The circuit court's decision denying Mr. Avery an evidentiary hearing on his new evidence of Bobby Dassey's, and then it's got in parentheses Bobby's, but in my opinion, it should say killer's, possession of Ms. Halbach's vehicle is based on an irrational premise, quote, that Bobby could have been in possession of the car that night, to help hide evidence to protect, now this is italicized, the two individuals directly linked by forensic evidence to this murder and convicted of the crime, unquote. Oh, is that a footnote? All right, first footnote. Citations of the record on appeal appear with the document number before the colon and the page number after the colon. A citation of, quote, 429:16, unquote, for instance, refers this court to page 16 of document 429. Citations to different documents in the record are separated by semicolons. Where available, parallel citations to the separate appendix appear in separate parentheticals after the citations to the record. Mr. Avery shall cite to the concurrently filed separate appendix as, quote, APP, and then in brackets, page numbers, unquote. Remember, I'm not a lawyer, and I don't pretend to be a lawyer. So I don't know all this lawyer stuff. But interesting enough, I work for an attorney now. I am chief of staff for a state representative. And prior to her being elected, she was an attorney. And at work today, I had told her I was waiting for Kathleen to send this to me, and then I would go live. And so it's like, I really should have my boss read this stuff now and explain it to me on things that I'm not the lawyer and I don't understand it. All right. Anyways, back up to where that. Okay. First, the circuit court is hugely mistaken in presupposing that Brendan Dassey was ever linked forensically to the crime. He was not. Second, the circuit court erroneously relies upon evidence that was barred from being considered at Mr. Avery's trial, such as Brendan Dassey's confession, to support its decision to deny Mr. Avery an evidentiary hearing. And now there's another footnote, which says, hello, Chechia. How do I say that? Is it Chechia? But hello, Gabriella. Such a pretty name, Gabriella. On June 6, 2007, in a letter attached to Mr. Avery's PSI report, Judge Patrick Willis evaluated the reliability of Brendan Dassey's confession as follows, quote, Brendan Dassey did not testify at the trial in this case. The jury was not required to assess the credibility of any statements attributed to him, unquote. Quote, charges of first-degree sexual assault and kidnapping, which were added to the information after the police interviewed Mr. Dassey, were dismissed by the state before trial, unquote. Quote, the account attributed to Mr. Dassey in the PSI is based on one of his interviews with police. He was interviewed by the police on other occasions during which he gave somewhat different accounts of what happened. He also at some point, this is a intentional misspelling, so it says some pointed, recanted his statements admitting involvement in the crimes, unquote. Quote, the physical and forensic evidence introduced at Mr. Avery's trial failed to provide corroborating support for a number of the allegations attributed to Mr. Dassey. As one significant example, there was no physical or scientific evidence demonstrating that Teresa Halbach was ever present in Mr. Avery's trailer, unquote. And, quote, an expert witness called on behalf of Mr. Dassey at his trial, one Dr. Gordon, and a Dr. White retained by Mr. Avery's counsel, both called into question much of the information provided by Brendan Dassey because of his intellectual limitations, his susceptibility. Hello, Gar from California. His susceptibility to suggested answers and the nature of the investigative techniques used, unquote. Back up. The circuit court's speculation is that when Bobby moved Ms. Halbach's vehicle onto the Avery property, it was his intent to help his uncle by hiding evidence. This is contradicted by the fact that all of the forensic evidence used to convict Mr. Avery was in the vehicle and was discovered because the vehicle had been moved onto the Avery property. Mr. Avery's blood and DNA was in the vehicle. Ms. Halbach's electronic devices from her vehicle were subsequently found in Mr. Avery's burn barrel, and the RAV4 key was later found in Mr. Avery's bedroom. None of this incriminating evidence was discovered until the vehicle was brought back to the Avery salvage yard by Bobby. In the circuit court's nonsensical conclusion, because these actions could be seen as an effort by Bobby to help Mr. Avery, he cannot be considered a valid third-party Denny suspect. The circuit court failed to explain why, if Bobby was simply lending a helping hand to his homicidal uncle, he would then become the state's star witness against Mr. Avery. Next section is titled Statement of the Case and Procedural History. This case began in early November 2005 by the disappearance of Teresa Halbach, a 25-year-old professional photographer. Ms. Halbach was reported missing on November 3, 2005. On November 5, 2005, volunteer searchers found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Mr. Avery and other family members lived and worked. Ms. Halbach had photographed vehicles at the site previously per Mr. Avery's request. According to state witness Bobby Dassey, the killer, Tanya, yes, this is something she just filed today. Ms. Halbach was last seen walking towards Mr. Avery's trailer on October 31, 2005. After finding Ms. Halbach's RAV4, law enforcement searched the Avery property and, over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit, the DNA matching Ms. Halbach's, with DNA, Mr. Avery's and Ms. Halbach's blood in the RAV4, the remnants of electronic devices and a camera, the same models as Ms. Halbach's, in a burn barrel, Ms. Halbach's RAV4 key in Mr. Avery's bedroom with Mr. Avery's DNA on it, Mr. Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by Mr. Avery's sweaty hands, and a bullet in Mr. Avery's garage containing Ms. Halbach's DNA. During Mr. Avery's trial, Bobby was the state's primary witness against Mr. Avery. The state used Bobby's testimony to establish that Ms. Halbach never left the Avery property alive. In his opening statement, Prosecutor Kratz explicitly told the jury of the significance of Bobby's putative observations on the date of Ms. Halbach's disappearance. Quote, "You are going to hear that Bobby was the last person, the last citizen that will have seen Teresa Halbach alive." Unquote. During the trial, Bobby testified that he observed Ms. Halbach's SUV pulled up in his driveway at 2:30 p.m. on October 31, 2005. Bobby testified that he then observed Ms. Halbach exit her vehicle and start taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he then observed Ms. Halbach walking towards the door of Mr. Avery's trailer. The following exchange occurred between Prosecutor Kratz and Bobby. Question: after seeing this woman walking toward your Uncle Stevens, did you ever see this woman again? Answer: no. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide, contrary to Wisconsin statute blah, and felon in possession of a firearm, contrary to Wisconsin statute whatever. The jury found Mr. Avery not guilty of mutilation of a corpse. Now we're on page 11 of 57. On October 11, 2019, Mr. Avery appealed the Circuit Court's denial of his second post-conviction motion and all of its supplements. He filed motions to stay and remand concerning 2 additional claims. At this court's direction, Mr. Avery raised his claims in his motions in the Circuit Court as supplemental post-conviction motions. The Circuit Court denied his motions to supplement. During the pendency of Mr. Avery's appeal, a new witness, Mr. Thomas Sawinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. Mr. Sawinski stated that he had witnessed Bobby and one other individual, a bearded man, pushing Ms. Halbach's RAV4 onto the Avery salvage yard in the early morning hours of November 5, 2005. Mr. Sawinski claimed that he had reported this information to the Manitowoc Sheriff's Office. On April 10, 2021, Mr. Sawinski provided an affidavit to Mr. Avery's current post-conviction counsel, stating that, quote, Mr. Sawinski was a motor route driver for Gannett Newspapers, Inc., and delivered papers to the Avery salvage yard in the early morning hours of November 5th of 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned onto the Avery property and witnessed 2 individuals, a shirtless Bobby Dassey and an unidentified older male, suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. Mr. Sawinski drove past the 2 men and delivered newspapers to the Avery mailbox, and then he turned around and drove back towards the exit. When he reached the RAV4 still over there, Bobby attempted to step in front of his car to block him from leaving the property. Mr. Sawinski came within 5 feet of Bobby, and his headlights were on Bobby during this entire time. Then Sawinski swerved into the shallow ditch to escape Bobby and exit the property. Mr. Sawinski states in his affidavit that he called out, quote, "Paperboy, gotta go," unquote, because he was afraid for his safety. He further stated that Bobby looked him in the eye and did not appear happy to see Mr. Sawinski there. After Mr. Sawinski learned that Teresa Halbach's car was found later in the day on November 5, 2005, he realized the significance of what he had observed and immediately contacted the Manitowoc Sheriff's Office. Hey, Ashley. On April 12, 2021, I should have said unquote, Mr. Avery filed a motion for remand and stay of appeal to this court containing Mr. Sawinski's original affidavit. On July 28, 2021, this court issued a per curiam, however you say that, opinion, upholding the Circuit Court's summary denial of Mr. Avery's claims raised in his post-conviction motion and 2 supplemental motions, holding that, quote, Avery's motions are insufficient on their face to entitle him to a hearing, unquote. State versus Avery. Blah, 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 all these numbers. However, this court did not remand Mr. Avery's case for a Circuit Court ruling on the claim in his most recent filing concerning the new witness, Mr. Sawinski. Hello, Christopher. And reserved Mr. Avery's ability to raise this issue in a successive motion. Specifically, this court instructed the following, quote, as discussed below, we are not addressing Avery's most recent filing to this is italicized, this court. See our discussion of motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin statute motion. That motion would need to survive both Escalona Naranjo scrutiny and be found to have merit, in which case, and now this is underlined, the evidence presented might supply the missing direct connection. In that event, the Valley CD might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such motion, as all such issues would be for the Circuit Court to decide in the first instance, unquote. Regarding certain claims Mr. Avery raised in his motion to reconsider the Circuit Court's October 3, 2017 order denying his second post-conviction motion and its two supplements, this court found, quote, "Neither we nor the Circuit Court have squarely considered whether these claims are procedurally barred under Escalona Naranjo or whether Avery pled sufficient materials entitling him to a hearing. Such consideration would have to come on a separately filed Wisconsin statute motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed." Unquote. Therefore, this court did not rule on certain issues contained in Mr. Avery's prior motion to reconsider and its two supplements. On August 16, 2022, Mr. Avery filed his third motion for post-conviction relief pursuant to whatever number. Mr. Avery filed an amended motion on December 6, 2022. Mr. Avery's motion set forth newly discovered evidence that third-party Bobby was seen in possession of the victim, Ms. Halbach's vehicle, after her disappearance. Mr. Sawinski contacted the Innocence Project about this matter in 2016. Although Mr. Sawinski originally believed it was Mr. Avery's trial defense attorneys that he contacted in 2016, after finding an email verification, he realized it was rather the Innocence Project he contacted, and thus he amended his original affidavit, which was submitted in Mr. Avery's motion to stay his appeal to this court. And Mr. Sawinski's amended affidavit was filed to the Circuit Court reflecting this mistake. Affidavits from two other witnesses in Mr. Avery's case, Dr. Kevin Romlow and Mr. Thomas Baresh, and the footnote for that says, in Mr. Romlow's affidavits provided to the Circuit Court, Mr. Romlow described observing Ms. Halbach's RAV4 parked at the turnaround at State Highway 147 and the East Twin River Bridge on November 3 and 4, 2005. Mr. Romlow stated that he reported his observation to a Manitowoc Sheriff's deputy he encountered on November 4, 2005 at the Senex station at State Highway 147 in Mishicot. In Mr. Thomas Baresh's affidavit, he states that sometime before 2 a.m. on November 5, he was driving a tow truck in the area of Highway 147 and County Road Q in Manitowoc County and saw RAV4 driving south on County Road Q, turning left off of County Road Q as it passed him. Although he did not recognize the passenger in the vehicle, he is 100% sure it was not Mr. Avery. Back up. Where was I? Okay. Corroborate Mr. Sawinski's observations. In Mr. Avery's motion, Mr. Avery also raised Brady claims relating to the information from the new witnesses. Mr. Avery attached affidavits and documents showing that after Mr. Sawinski contacted Mr. Avery's current post-conviction counsel and provided the newly discovered evidence, Mr. Avery's current post-conviction counsel, through its investigator, submitted its second public records request pursuant to the Freedom of Information Act, FOIA, for audio recordings of incoming and outgoing phone calls and or radio dispatches between November 3, 2005 and November 9, 2005 relating to the case. The FOIA-produced audio recordings did not contain the Sawinski call, nor did they contain any dates or times of the calls produced. Dun, dun, dun. In May of 2022, Mr. Avery's current post-conviction counsel received the previously suppressed Sawinski call to the Manitowoc Sheriff's Office, which contained a partial recording of the suppressed call to the Manitowoc Sheriff's Office on November 6th. For the first time, current post-conviction counsel received the exact dates and times of the Manitowoc County Sheriff's Office incoming calls. As part of its investigation, Mr. Avery's investigator then interviewed Mr. Sawinski's ex-girlfriend, whom he was dating at the time of the November 5, 2005 incident. Mr. Sawinski's ex-girlfriend, Devin Novak, corroborated Mr. Sawinski's account of what he had witnessed and what he had relayed to law enforcement. Further, Ms. Novak recognized and identified Mr. Sawinski's voice on the recording, played to her by the investigator, of a phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery's investigator interviewed Mr. Sawinski again and played the same audio recording of the phone call that was made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Sawinski identified his voice in the audio recording of the phone call from November 6, 2005. The recording of Mr. Sawinski's call was never disclosed by the state to Mr. Avery's trial defense counsel prior to or during the trial. Pre-trial, trial defense counsel made two specific requests for all exculpatory evidence and or information within the possession, knowledge, or control of the state which would tend to negate the guilt of the defendant, or which would tend to affect the weight or credibility of the evidence used against the defendant, including any inconsistent statements. Pertaining to the Brady claim stemming from the evidence from Mr. Romlo, Mr. Romlo described in his affidavit that he reported his observation to a Manitowoc Sheriff's deputy he encountered on November 4, 2005 at the Senex station at Highway 147 in Mishicot. No law enforcement report was ever generated by this Manitowoc Sheriff's deputy memorializing the conversation between Mr. Romlo and this deputy about Mr. Romlo's observation of Ms. Halbach's vehicle. The Circuit Court denied Mr. Avery's motion for post-conviction relief on August 22, 2023. Mr. Avery filed a timely notice of appeal on August 24, 2023. This appeal follows. Argument 1. Whether this court must conduct a de novo review of the sufficiency of Mr. Avery's motion for post-conviction relief on its face because of the Circuit Court's failure to conduct any such analysis as a matter of law? In the Circuit Court's opinion dismissing Mr. Avery's third motion for post-conviction relief, the Circuit Court failed to consider Mr. Avery's request for an evidentiary hearing. Pause for water. And we're now on page 16 of 57. The Circuit Court, quote, must determine first whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief, unquote. State versus Ruffin, citing State versus Allen. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Gritzner versus Michael R. Only after an evidentiary hearing is the court charged with determining the issues and making findings of fact and conclusions of law. The Circuit Court improperly attempted to weigh Mr. Avery's facts with speculative theories unsupported by the record rather than accepting his facts as true and determining whether they were sufficiently pled to warrant an evidentiary hearing. Despite the fact that the Circuit Court opened its opinion claiming, quote, the defendant is back before the Circuit Court, unquote, the Circuit Court failed to conduct any analysis on whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing on his newly discovered evidence. Rather, in its opinion, the Circuit Court weighed Mr. Avery's evidence as if it had already been presented during an evidentiary hearing. An evidentiary hearing is nothing more than an intermediate step toward the objective of being granted a new trial. It is not an end in itself. An evidentiary hearing is a forum to prove allegations in a motion for post-conviction relief. See State versus Balliet. Mr. Avery's motion for post-conviction relief states what he is set to prove if he were granted an evidentiary hearing. An evidentiary hearing would provide Mr. Avery with the opportunity to move his pleaded claims that he is entitled to a new trial. If Mr. Avery's motion contained all the proof necessary to show that he was entitled to a new trial, he would not need an evidentiary hearing. In Mr. Avery's prior appeal to this court, after the circuit court denied his second motion for post-conviction relief, this court properly was guided by the law for determining whether an evidentiary hearing is warranted. This court correctly stated the law, quote, where, as here, a defendant appeals the circuit court's denial of a Wisconsin statute motion without an evidentiary hearing, then the question before us is narrow. Whether remand for a hearing is warranted because the circuit court erred in denying the motion on its face, unquote, citing Balliet. This court correctly noted the two potential standards. Oh, my back is starting to hurt. For determining whether the circuit court erred in failing to grant an evidentiary hearing. The first being, quote, the circuit court must hold a hearing whether the motion is sufficient on its face unless the record as a whole otherwise conclusively demonstrates that the defendant is not entitled to relief, unquote. Additionally, this court noted, quote, if the motion does not raise sufficient facts or presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, then the circuit court has the discretion to grant or deny a hearing, unquote. In such a case, this court reviews for an erroneous exercise of discretion. Here, the circuit court never conducted any analysis on whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing, nor made the requisite finding pursuant to State v. Jackson that, quote, the record conclusively demonstrates that the defendant is not entitled to relief, unquote. This court should reverse the circuit court's ruling denying Mr. Avery's motion because it failed to make the requisite findings established by case law. Section 2, or point 2, whatever you want to say. Whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove. Sorry, my phone just went off, and usually it's over here so I can see it, and I just saw the flash. Whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmonds and Brady v. Maryland. This circuit court misapplied State v. Edmonds by requiring Mr. Avery to conclusively establish Bobby's motive to murder Ms. Halbach in his motion, and this is italicized, on its face, and in order to satisfy the materiality requirement of Edmonds. A. Standard of review. An appellate court reviews a circuit court's determination as to whether a defendant has established his or her right to a new trial based on newly discovered evidence for an erroneous exercise of discretion. A court properly exercises its discretion if it relies on the relevant facts in the record and applies the proper legal standard to reach a reasonable decision. Thus, this court will find an erroneous exercise of discretion if the circuit court's factual findings are supported by the evidence, and this is underlined, or if the court applied an erroneous view of the law. B. Burden of proof. On a motion of post-conviction relief pursuant to Wisconsin statute, whatever, a defendant has the burden of proof. The defendant must show his entitlement to relief by clear and convincing evidence. To obtain an evidentiary hearing on a motion for a new trial on the basis of newly discovered evidence, the defendant first, quote, must show specific facts that are sufficient by clear and convincing proof, unquote, to demonstrate that, quote, 1. The evidence was discovered after conviction. 2. The defendant was not negligent in seeking the evidence. 3. The evidence is material to an issue in the case. And 4. The evidence is not merely cumulative. C. Argument. The circuit court found that Mr. Avery satisfied. Okay. Sorry. I thought it was a footnote, but it's not. The circuit court found that Mr. Avery satisfied all the elements required to admit his newly discovered evidence, the Sawinski evidence, but for the materiality requirement of Edmonds. The circuit court imposed a new Denny requirement that Mr. Avery must establish that Bobby had a motive established by conclusive evidence to commit the murder of Ms. Halbach to meet the Edmunds materiality requirement. Specifically, the circuit court stated, Georgia Ann, yeah, there is tons of evidence that was not on Netflix Making a Murderer. And the more you look at the actual evidence, the more it shows that Stephen and Brendan are innocent. All right. So, quote, a review of the record and the defendant's argument revealed that he has failed to satisfy the third standard of the Edmunds test, as well as the motive element of the Denny test. With respect to the Edmunds test, the defendant argued that the evidence offered was material to an issue in the case because it established that there was a viable third-party suspect that could have committed the murder of Ms. Halbach, and such evidence was never presented to the jury for consideration, undermining confidence in the verdict reached. In order to meet that burden, the defendant had to prove that the evidence also met the standard set forth in Denny to be admissible as proof as a third-party suspect. The defendant failed to establish that Bobby had the requisite motive to commit the murder of Ms. Halbach. Unquote. Now I'll go back to Georgia Ann. This is a supporter page for Stephen Avery. We 100% believe in both Stephen and Brendan's innocence here. This is not a place that we debate this case. You are entitled to your opinion. You're not entitled to your own facts. And we don't debate here. There are plenty of other pages out there where guilters are free to post their opinions. But here on Stephen Avery Project, we go by facts and science. And all of that shows that Stephen and Brendan are innocent. So you are entitled to be here and watch me, but we do not allow posts saying they are guilty. So do I not believe in free speech? Now I'm going to get so derailed here. Yes. And now Christopher just removed you. I do believe in free speech, but I have a microphone and you don't. This is my page, my rules. So I'm not saying you can't have free speech. Go say it wherever you want, anywhere else. You're just not going to say that stuff here. I do not allow false facts here. Sorry. Thank you, Christopher. All right, back to reading the filing. According to the circuit court, Mr. Avery would have to satisfy two tests for the circuit court to admit, quote, the affidavit of Sawinski, unquote, into evidence. The circuit court improperly found that the materiality of Mr. Avery's newly discovered evidence is exclusively contingent upon its satisfaction of the Denny test for admissibility of potential third-party suspect evidence. In determining that Mr. Avery's new evidence could only be material to the issue of a potential third-party suspect, the circuit court completely ignored the inherent materiality of the Sawinski evidence to other material issues in Mr. Avery's case. Vin says, when is an appeal likely to be agreed? I don't know. I never remember. This is something maybe I should ask my boss, or maybe I should ask Kathleen. I don't know how long now that the state has to respond, and then how much time that the judge has to respond. I never know how that all works. And Craig says, is Lauren Nyrider still working on getting Brendan out? Does he have any options, or is it all down to Kathleen getting Stephen out? Keep up the good work. Lauren Nyrider will always be with Brendan. So Laura Nyrider and why am I blanking on Steve's name? Drizzen. sorry, Stephen Drizzen, they will always be there for Brendan, but the the difference between Brendan's case and Stephen's case is Brendan confessed. And it's so hard to overturn a false confession. And anybody with two brain cells can see what was done to Brendan to get him to say the things that he said. But sadly, Brendan Brendan doesn't have much hope at this point. And even if Kathleen gets Stephen out on whatever way she's able to do it, it doesn't mean Brendan gets to go either, because they were both tried for two different scenarios. And there are people that think that everything Brendan was led to say, he said Stephen did it, but really it was Bobby. So that Brendan is still a part of it. So, so there's a lot more to it to get poor Brendan released. All right, where was I? In Mr. Avery's third motion of post-conviction relief, he argued, hey, Chelsea, the Sawinski evidence is material to several issues in Mr. Avery's case. It is material for establishing Mr. Avery's defense. That is, that a third party committed the crime against Ms. Halbach. Additionally, the Sawinski evidence is material to the evidence in the RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Sawinski evidence is material to impeach Bobby's trial testimony that Ms. Halbach never left the Avery property and that she was last seen walking towards Mr. Avery's trailer. You're welcome, Craig, and hello, Joe from Nottinghamshire, UK. The new evidence showing that Bobby had possession of Ms. Halbach's vehicle is highly material for evaluating the reliability of the forensic evidence used against Mr. Avery, which all happened to be derived from Ms. Halbach's vehicle. Crucially, it is also material to the reliability of the state's key witness against Mr. Avery, Bobby himself. We're on page 21 of 57 now. This court pointed out in paragraph 4 of its opinion from July 28, 2021, hello, Dawn from Prince Edward Island. Quote, the state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher, unquote. Mr. Avery's new evidence shows that the vehicle did leave the Avery property and was in possession of a third party. Additionally, this new evidence debunks the state's theory against Mr. Avery that he kept the RAV4 on the Avery property by the crusher so he could crush it immediately. And Sue from Yorkshire, UK. Hello, all you from the United Kingdom. The evidence of Bobby's possession of Ms. Halbach's vehicle is material because it shows that Bobby had possession of the forensic evidence used to convict Mr. Avery. The vehicle was the crime scene by virtue of having all of the relevant forensic evidence in it, including Ms. Halbach's blood. The Sawinski evidence establishes that Bobby, the state's star witness, had control of the crime scene for a period of time. Despite police searches preceding the discovery of Ms. Halbach's vehicle, Ms. Halbach's electronic devices and key were not found until after Ms. Halbach's vehicle was found. The only logical conclusion to explain this is that all the items remained in Ms. Halbach's vehicle and were then moved by whoever had possession of her vehicle. If a third-party suspect had possession of Ms. Halbach's vehicle, numerous areas of reasonable doubt arise, such as the forensic evidence in the vehicle is tainted by the third party having control of it before, the word before is italicized, it was discovered by law enforcement on the Avery property. This would have created reasonable doubt in the jurors' minds, particularly since the state's star witness was the one in possession of the vehicle. Thus, Mr. Avery's new evidence also presents an alternative theory for the source of the forensic evidence used against Mr. Avery. State versus Edmonds is the leading case on newly discovered evidence. In Edmonds, the defendant was convicted of the death of an infant she was caring for at the time of the infant's death. The defendant filed a motion for a new trial over a decade after her trial and offered medical testimony that showed that there had been a shift in mainstream medical opinion as to the cause of the types of injuries the infant suffered. The court found that the evidence was material to an issue in the case because the main issue at trial was the cause of the infant's injuries, and the new medical testimony presented an alternate theory for the source of those injuries. Sounds like Melissa Kalyazinski. Here, applying Edmonds, Mr. Avery's new evidence is material to a key issue in Mr. Avery's case because Mr. Avery's new evidence that Bobby had possession of Ms. Halbach's vehicle after her murder presents an alternative theory for the source of the evidence used to convict Mr. Avery. The Sawinski evidence is additionally material because it completely calls into question the reliability of the state's key witness, Bobby's testimony, which allowed the state to argue that Mr. Avery had exclusive control of Ms. Halbach and her vehicle, which contained all of the forensic evidence, and that this evidence was not tainted by any third party. During its closing argument, the state emphasized the importance of Bobby's testimony and vouched for his credibility. Quote, again, an eyewitness without any bias. It is individual, A is intentionally the wrong grammar. It's marked in here as intentional. It is a individual that deserves to be given a lot of credit, unquote. With the new Sawinski evidence, as well as Mr. Romlow's affidavit, the state could not possibly have presented Bobby to establish that Ms. Halbach never left the property in her vehicle and that she was last seen walking towards Mr. Avery's trailer. The state's critical witness link to obtaining Mr. Avery's conviction. Clearly, by Bobby possessing the Halbach vehicle, there is a reasonable likelihood it would have affected the judgment of the jury in that Bobby would have emerged as a much more likely suspect in the murder of Ms. Halbach than his recently released, wrongfully convicted uncle. Contrary to the state's representations to the jury, Bobby was biased and deserved no credit for his fabricated testimony. Hello, Kelly, also from the UK. And Craig says, one last thing from me as it's late in the UK. Are the producers of Making a Murderer still following the case? Is there plans for a follow-up series? And lastly, have they spoken to you about what you do to get Stephen out? Okay. I do not have any contact with the documentarians of Making a Murderer. I've only spoken to them one time, and that was at Brendan's hearing at the Seventh Circuit in Chicago. I am sure that they follow everything that happens in this case, and this is my opinion, if Stephen was to get an evidentiary hearing or a new trial, or what should happen for him, that he should be released and then he owns the state of Wisconsin, they absolutely would put out another series. Netflix would be happy to air another series, I am sure, because it does such good numbers for Netflix. The documentarians are aware of me and what I do, but I do not have contact with them. And there's Christopher plugging my book, Wrongfully Abused. Here it is. And Cadillac Bubba from Virginia and Stuart from the UK. Hello, everybody. All right, going back to where I was. Hold on. Okay, this is where I'm at. The United States Supreme Court in Weary versus Kane held Brady applies to evidence undermining witness credibility. Evidence qualifies as material when there is, quote, any reasonable likelihood, unquote, it could have, quote, affected the judgment of the jury, unquote. To prevail on his Brady claim, Weary need not show that he, quote, more likely than not, unquote, would have been acquitted had the new evidence been admitted. Additionally, in regard to a motion for a new trial, a reasonable doubt as to a defendant's guilt has been found to exist when the reliability of a witness critical to the state's case is completely called into question by newly discovered evidence, State versus Wilson. Quote, a new trial is required if the false testimony could, in any reasonable likelihood, have affected the judgment of the jury, unquote. In State versus Plude, the defendant presented newly discovered evidence that an expert witness lied about his credentials. The Supreme Court of Wisconsin found that because, quote, the expert witness's testimony was a critical link in the state's case, unquote, quote, the expert witness's quasi-medical expert testimony creates a reasonable probability that the jury hearing of his false testimony about his credentials would have had a reasonable doubt as to Plude's guilt, unquote. Notably, in Justice Annette Ziegler's concurrence with the majority opinion, she wrote that, quote, new allegations, unquote, that the expert witness misrepresented his credentials about his affiliations and work experience created a serious question as to whether the interests of justice were served, unquote. Here, Mr. Avery presents a stronger case about the materiality of his newly discovered evidence because he does not just allege that it shows that Bobby misrepresented facts in his testimony. He alleges that the Sawinski evidence shows that Bobby committed perjury in his testimony, that he left the property and did not see Ms. Halbach again. Furthermore, the newly discovered evidence taints all of the forensic evidence used against Mr. Avery, which resulted in his conviction. In this court's previous opinion on July 28, 2021, this court did not believe that the impeachment of Bobby was material because it found that there was significant forensic evidence linking Mr. Avery to the crime. However, the Sawinski affidavit establishes Bobby's possession of the Halbach vehicle undermines confidence in the reliability of the forensic evidence used against Mr. Avery. This strengthens the materiality of the impeachment evidence against Bobby. Hey, Carrie, in Birmingham. In his motion for post-conviction relief, Mr. Avery satisfied Edmonds. Once the four criteria of newly discovered evidence have been established, the court looks to whether a reasonable probability exists that a different result would be reached in a trial. The reasonable probability factor need not be established by clear and convincing evidence, as it contains its own burden of proof. With regard to a motion of a new trial, the correct legal standard when applying the, quote, reasonable probability of a different outcome, unquote, criteria is whether there is a reasonable probability that a jury, looking at both the old and the new evidence, would have a reasonable doubt as to the defender's guilt. Quote, a court reviewing newly discovered evidence should consider whether a jury would find that the newly discovered evidence had a sufficient impact on other evidence presented at trial that a jury would have a reasonable doubt as to the defendant's guilt, unquote. Here, the circuit court, again, failed to analyze Mr. Avery's evidence under the proper test because of its improper requirement that Mr. Avery satisfy the Denny motive prong in order to show the materiality of his evidence, even for purposes of Brady. The circuit court did not dispute that the prosecution had suppressed the audio recording of Mr. Sawinski's call. Rather, it disputed the materiality and favorability of the evidence to find that Mr. Avery failed to establish a Brady violation with respect to the Sawinski evidence. Trudy, I'm with you. Yeah, it's shocking that Stephen can't even get back into court with all the evidence there is. We're now on page 26 of 57. Rather than making the required finding that there was no reasonable probability that a jury, hearing Mr. Avery's new evidence, could have a reasonable doubt as to Mr. Avery's guilt, the circuit court engaged in weighing the evidence of the violent porn found on the Dassey computer and concluded that the evidence does not conclusively show that it was solely acquired by Bobby on the computer. Section 3. Whether the circuit court erred when it did not correctly apply State versus Denny to Mr. Avery's potential third-party suspect evidence. In his motion for post-conviction relief, Mr. Avery presented evidence implicating his constitutional right to present a defense that a potential third party committed the murder of Ms. Halbach. However, the circuit court did not correctly apply Denny to the admissibility of Mr. Avery's evidence of a potential third-party suspect. It erroneously imposed a substantial certainty requirement upon Mr. Avery's evidence and completely misapplied Denny in its evaluation of whether Mr. Avery's evidence satisfied the Denny elements of motive, opportunity, and direct connection. A. Standard of review. This court generally reviews a trial court's decision to admit or exclude evidence under an erroneous exercise of discretion standard. State versus Wilson. However, when a defendant's constitutional right to present a defense is implicated by the exclusion of evidence, the decision not to admit the evidence presents a question of constitutional fact that this court reviews de novo. State versus Ramsey, State versus Knapp. B. Burden of proof. On a motion for post-conviction relief pursuant to section whatever, the defendant has the burden of proof and must show his entitlement to relief by clear and convincing evidence. Rawls versus State. Hey, Alan. More water. I keep hearing something. I don't know if Jeff's walking up here. Denny governs the admissibility of potential third-party perpetrator evidence in Wisconsin. Denny requires a showing that, quote, there must be a legitimate tendency that the third person could have committed the crime, unquote. State versus Denny. A legitimate tendency is demonstrated where the defendant can establish 1. Motive, 2. Opportunity to commit the charged crime, and 3. God, my throat sucks right now. And 3, provide, quote, some evidence to directly connect a third person to the crime charged with, which is not remote in time, place, or circumstances, unquote. In its opinion, dismissing Mr. Avery's motion for post-conviction relief, the circuit court acknowledged that the standard for evaluating the admissibility of evidence of a potential third-party suspect is set forth in Denny. However, rather than applying the Denny standard, the circuit court applied a stricter standard, which Wisconsin does not follow. Hello, Adrian from Scotland. However, rather than applying the Denny standard, I read that already. In Denny, the Wisconsin Court of Appeals rejected the standard set forth by the California Supreme Court in People v. Green, 1980. Specifically, the Denny court disagreed with, quote, the Green court's conclusion that such evidence must be substantial, unquote, stating, quote, we perceive this to be too strict a standard for the admissibility of such evidence in conflicts with our Supreme Court's pronouncements on the fundamental standards of relevancy, unquote. Denny at 623. The Denny court clarified, quote, Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. This rule does not say that the evidence must tend to prove a fact in a substantial, that's italicized, substantial way, unquote, rather than requiring any level of substantial certainty. Denny adopted the standards set forth in the earlier Supreme Court case, Alexander versus United States, 1891. There, the Supreme Court fashioned the legitimate tendency test, where the standard for evaluating the evidence is that it must show a legitimate tendency that the third party could have committed the crime. In adopting the Supreme Court's test for materiality, the Denny court elaborated, quote, "We believe that to show legitimate tendency," and now the end of this sentence is all underlined, "a defendant should not be required to establish the guilt of third persons with that degree of certainty requisite to sustain a conviction in order for this type of evidence to be admitted." So again, I hate the hypocrisy that you don't have to have a reason Stephen killed Teresa Halbach. The state doesn't have to have any proof of any reason why. They can just say Stephen did it. But for Stephen to say that there's another witness, you have to prove that the person's guilty and why they would do it. That makes no sense. Oh man. If the circuit court had correctly applied Denny, it would have found that Mr. Avery has provided sufficient evidence to satisfy the standard set forth by Denny. The Denny court differentiated between evidence which supports a legitimate tendency and, quote, evidence that simply affords a possible ground of suspicion against another person, unquote, which is merely evidence, quote, tending to show that hundreds of other persons had some modem or animus against the deceased, unquote. Unlike the inadmissible type of evidence that the Denny court described, Mr. Avery's evidence is very specific to Bobby and establishes a direct connection between Bobby and the crime. Hundreds of other persons did not have possession of Ms. Halbach's vehicle. And also, are you talking to me? No, he's talking to the dogs. And also have the photographs of young, mutilated females on the computer, of which they are the primary user. And now in parentheses it says, quote, the legitimate tendency test asks whether the proffered evidence is so remote in time, place, or circumstances that a direct connection cannot be made between the third person and the crime, unquote, end of parenthesis. Again, Denny does not require a conclusive showing of Bobby's guilt. Rather, it establishes a standard for establishing a potential third-party suspect, which is a material issue in any murder case. Denny states that, quote, as long as motive and opportunity have been shown, and as long as there is also some is italicized, evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances, the evidence should be admissible, unquote. Where Mr. Avery has proffered evidence that Bobby Dassey had possession of Ms. Halbach's vehicle after she went missing, had most likely been conducting computer searches relevant to Ms. Halbach's murder, and was on the Avery property before Ms. Halbach's disappearance and after her disappearance, no reasonable trier of fact correctly applying the law would find that Mr. Avery has not established some evidence directly connecting Bobby to the crime charged. And see, I get it that you can't just go, well, maybe the mailman did it. And having no evidence and just, trying to throw red herrings out there. So I get there being a rule that you just can't say, well, maybe the milkman did it. It could have been this person. It could have been customers at Avery Salvage. I get that you need something more substantial in suggesting another suspect, which they've done with Bobby Dassey. So now this section, number 1, says the circuit court erroneously evaluated the motive, opportunity, and direct connection elements of Denny. As this court pointed out in its opinion previously, the evidence in support of Denny must be viewed in the aggregate. Rather than viewing Mr. Avery's evidence in the aggregate, the circuit court required Mr. Avery to present conclusive proof to satisfy each prong individually. However, quote, each piece of a defendant's proffered evidence need not individually satisfy all 3 prongs of the Denny test, unquote. Further, the Wisconsin Supreme Court has determined that the strength in proof of one of the prongs may affect the evaluation of the other prongs. See State versus Wilson. The circuit court completely ignored these well-established principles of law in evaluating the motive, opportunity, and direct connection elements of Denny. Section 2. Motive element of Denny. In Mr. Avery's motion for post-conviction relief, he alleged that the motive attributed to Bobby for Ms. Halbach's murder could have been sexual and provided evidence supporting this, namely the suppressed evidence from a computer that was in Bobby's bedroom, according to his brother Blaine's affidavit. Bobby was the primary user of this computer. Bobby lied to police about the location of the computer, claiming it was in the living room, but crime scene footage showed it was in his bedroom. The computer was examined and revealed searches highly relevant to the murder of Ms. Halbach, which occurred during times in which the state has been unable to rule Bobby out as having conducted them. The state argued that other members of the Dassey household could have conducted the searches, a supposition that may or may not be true, but no other member of the Dassey household was spotted by a witness with Ms. Halbach's vehicle shortly after her disappearance. Bobby's possession of the vehicle, with all of the forensic evidence used to convict his uncle, combined with the violent pornographic searches on the computer in his bedroom, of which he is the primary user, elevate him to the level of a Denny third-party suspect. And I always wonder if all this stuff that's been discovered about Bobby Dassey, if there was proof that Stephen did these things, what would the state do with that? Would the state just, this is nothing? They would have been all over those things. Now we're on page 31 of 57. The circuit court spent 12 pages of its 31-page opinion weighing Mr. Avery's motive evidence, which is improper and contrary to the law on motive. The issue is whether the pornographic searches on the Dassey computer are, now the word relevant is italicized to motive, and now this is italicized, regardless of the weight. Instead of the state constantly wanting to try and say, well, there's no proof that this was Bobby's, they've gone so far as to say it could have been Stephen going into Barb's house to look in porn when he's got his own computer and internet. Why would he go into his sister's house to do that when his girlfriend is in jail for being the drunken fool that she is? Why would he go look up porn? And then you see, or that everybody else related in the Dassey family are at work or school at those times. It's more likely than not Bobby Dassey. He's the only one off of work at those times when that's happening. So why are they so desperate to defend Bobby? Why are they so desperate to keep an innocent man in prison? In its opinion, the circuit court noted, quote, the state further disputes the defendant's conclusions that law enforcement considered pornography or sexual assault as a motive for the murder in this matter, unquote. In dismissing Mr. Avery's motive evidence, the Circuit Court adopted this erroneous position from the state's response brief. However, this point is completely refuted by the record. On March 10, 2006, the state filed an amended information against Mr. Avery, adding the charge of sexual assault, among others. This amended charge was the result of Brendan Dassey's confession. On March 1, 2006, Mr. Avery's trailer and his computer were searched extensively for pornography, and none was found. Detective Veli was asked to generate a report of Mr. Avery's computer. Based on Detective Veli's report, no apparent searches of pornographic and or sexual images were made, and no websites with apparent sexual and or pornographic images were accessed. In further search for evidence to support a sexual assault motive, the Dassey computer was seized by law enforcement on April 21, 2006. In the affidavit for search warrant for Dassey computer, Special Agent Tom Factbender testified, quote, "Your affiant believes that said computer may contain images, records, and messages which may be relevant to the investigation into the homicide of Teresa Halbach. Your affidavit further believes that information contained on said computer," and now this is italicized, "may include evidence of the crimes of homicide, mutilating a corpse, and sexual assault," unquote. Again, the Circuit Court misstated the evidence by relying upon the state's misrepresentations that the investigation was not focused on a sexual motive. Law enforcement made great efforts to extract all the pornography from the Dassey computer, and even went so far as to have Detective Veli, I pronounce that name differently every time I say it, conduct a specific word searches, and this is italicized, related to the murder, in an effort to connect the pornography to the murder. The specific search terms results were body, stab, throat, bullet, DNA, fire, gas, RAV, gun, handcuff, bondage, blood, and tire. The Veli CD contains the state's recovered pornography. Every time I do this, it's because something's italicized. It's not because I'm a total douche. The state's recovered pornography images relevant to the Halbach murder. On the CD, Detective Veli refined 14,099 images on the 7 DVDs and recovered 1,625 violent pornography images, this is italicized, that had been deleted. The CD contains thousands of images of violent pornography, criteria, word searches, registry, internet history, Windows history, and all MSN messages, all of which reveals a propensity for sexual violence. Without an evidentiary hearing, it cannot be conclusively established that Bobby was conducting these searches. Yet, when Mr. Avery provided sufficient evidence concerning the schedules of the occupants of the Dassey residence to eliminate certain individuals who could have had access to the computer from many of the violent pornographic searches, Mr. Avery has been unable to get an affidavit from Bobby admitting he conducted the searches, nor someone from the Dassey household stating they saw Bobby performing the searches, which the Circuit Court seems to be requiring. Moreover, Bobby did not volunteer for a forensic or psychological examination by Mr. Avery's experts, as the Circuit Court suggests is required. Based upon the findings of Mr. Gary Hunt, Mr. Avery's forensic computer expert, 667 sexual content searches were performed in total. Of those searches, 562 were performed on 10 weekdays between 6 a.m. and 3:30 p.m. On 8/16/2005, 4 searches. 9/13/2005, 12 searches. 2/23/2005, 48 searches. 3/29/2006, 37 searches. 3/30/2006, 23 searches. 4/3/2006, 93 searches. 4/5/2006, 96 searches. 4/6/2006, 14 searches. 4/13/2006, 39 searches. 4/19/2006, 196 searches. Therefore, 64 sexual content searches were performed prior to Ms. Halbach's murder between 6 a.m. and 3:45 p.m. when Bobby was allegedly home alone, if the family's reported schedules are taken to be true. Another 500 searches were performed in the same time frame after the murder when Bobby was supposedly home alone. In its response to Mr. Avery's motion for post-conviction relief, the state conceded that Bobby is at least connected to 3 of the most violent searches prior to Ms. Halbach's murder, and inadvertently conceded that Bobby is connected to 25 of the searches after Ms. Halbach's murder. Bobby cannot be eliminated by the state from any is italicized, from any of the pornographic searches, especially the ones conducted prior to and very close in time to Ms. Halbach's murder. And he is the only family member who was seen with Ms. Halbach's vehicle after her disappearance. The circuit court erroneously concluded that the searches done after Ms. Halbach's murder have no weight. However, conduct of a suspected person after the crime is a legitimate subject for consideration as bearing upon the probability of his guilt. Motive can manifest itself after the crime when the perpetrator is reliving and fantasizing about the crime. The continued searches for violent pornography demonstrate that the motive for this murder was a sexual assault. It is highly significant that the searches for deceased, mutilated young women began after, italicized, not before the murder and mutilation of Ms. Halbach. The searches after the murder coincide with the fact that a young woman was murdered and mutilated. The searches before the murder coincide with thousands of images of young women engaging in sexual activity, many unwillingly, and corroborate a sexual assault motive. See State versus Silva. The circuit court also completely ignored Mr. Avery's evidence of the Dassey computer deletions, which infer a consciousness of guilt. Significantly, many of the Dassey computer searches had been deleted, and only some of those were recovered, which leads to questions such as, who in the Dassey household deleted the searches? Why were these searches deleted before Mr. Avery's trial? To make the proper credibility findings on this issue, an evidentiary hearing must be held. It is highly significant in any investigation if there is an attempt to delete or destroy records. See State versus Renier. This is in parentheses. In this sexual assault case, the appellate court found, quote, the defendant's consciousness of guilt was also evidenced as he told the victim to delete the text messages the two had exchanged, unquote, and close parenthesis. See also State versus Mercer. And now this is in parentheses, where the appellate court found the fact that, quote, the jury heard evidence from which it could infer that Mercer deleted the files where the forensic examiners would have found the child pornography stored in his hard drive, unquote, was significant evidence of the defendant's guilt. End of whatever. Mr. Hunt identified 8 times when there were deletions on the Dassey computer. Those deletions are very important because they correlate with Ms. Halbach's visits to the property. Ms. Halbach visited the property on, and now the dates are in bold, on August 22, 2005, and there were deletions on the Dassey computer from August 23, through August 26, 2005. She visited the property on August 29, 2005, and there were deletions from August 28, 2005 through September 11, 2005. Hey, Debbie. Yep, I'm doing well. She visited the property on September 19, 2005, and there were deletions from September 14, 2005 through December 15, 2005. There are also deletions from September 24, 2005 through October 24, 2005. Most significantly, around the time of her murder on October 31, 2005, there were deletions from October 26, 2005 to November 2nd, 2005. Beginning November 3rd, 2005, there were further deletions made on the Dassey computer. These deletions at the above described relevant times cannot simply be dismissed as mere coincidences. Hello, Bob. The Circuit Court misconstrued the holding in Dressler versus McCautry by adopting the state's argument that the pornographic images must be a mirror image of the crime or they have no relevance, which is just ridiculous. The court in Dressler made no such ruling and held that, quote, the pictures depicting violence were offered to prove Dressler's fascination with death and mutilation. And this trait is italicized, trait of Dressler is undeniably probative of a motive, intent, or plan to commit a vicious murder, unquote. Likewise, here, most of the Dassey computer pornography consists of images, now we're going on to page 36 of 57, depicting violence, even race car accidents, that show a fascination with death and mutilation. And this trait is again emphasized, of the Dassey pornographic consumer is, quote, undeniably probative of a motive, intent, or plan to commit a vicious murder, unquote. Mr. Avery provided the Circuit Court with specific searches on the Dassey computer of terms such as, quote, someone who was shot, unquote, and searches for a, quote, gun to head, unquote. There were 8 searches prior to Ms. Halbach's murder on 9/17/05 for skeleton and a live skeleton. After the murder, there were 6 searches for girl guts and 15 searches for girl hurt and 2 searches for seeing bones hot girls. These searches mirror the fate of someone hurt, shot in the head, mutilated, and burned into skeletal remains, which is the total amount of information known about Ms. Halbach's fate. More importantly, these images reveal the trait, again, trait is emphasized, of the Dassey pornographic consumer that is probative of motive, intent, or plan to commit a vicious murder. Hello, Jenny. What was that noise? Oh, thank you, Jenny. Okay. Contrary to the Circuit Court's view, the proper standard does not require Mr. Avery to establish his evidence of Bobby's motive with absolute certainty. In fact, this level of certainty has never been required by any court in Wisconsin to satisfy the motive element of Denny, or any element of the Denny analysis for that matter. See State versus Knapp. In parenthesis, where the Wisconsin Supreme Court has even deemed hearsay evidence as permissible evidence for satisfying all 3 prongs of the Denny test, including motive. End bracket. Under the motive prong, the court simply must question whether, quote, the alleged third-party perpetrator had a plausible reason to commit the crime, unquote. I don't either, Adrian. Actually, I think the court does see it. But they just don't want Stephen to get out. Okay. Sorry, I always lose track of where I am when I look over here, squirrel. Mr. Avery's third party motive evidence is relevant regardless of the weight assigned to it by the circuit court. This is precisely in line with this court's prior guidance that if Mr. Avery's new direct connection evidence survives Escalona Naranjo scrutiny and has merit, the motive evidence found in the Veli CD, quote, might become relevant is italicized, to showing Bobby Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect, unquote. Yeah, I know. Knock on wood, Amanda. Here's hoping new judge actually. You would. I really need to talk to people that I know that are lawyers and judges on why, if I, you would think state and judges and are supposed to care about justice. And so mistakes happen, okay? Now, in Stephen's case, obviously, we know this wasn't mistake and stuff was intentional to try and frame Stephen for this. But normally, okay, mistakes can happen. Or, when cases happened before, science got to where it is today with DNA and all of that, whoops, oh my God, this was really bad that somebody's been in prison for something they didn't do. And now we have the science to show that it wasn't them. A judge shouldn't be desperate to try and keep a person still in there and not hear new evidence. It drives me crazy. Let me go back to comments that were made while I was talking. Adrian says, but would they not rather Stephen, who is actually innocent, out, and Bobby, who's actually guilty, in? It's so weird, especially Teresa's family. I understand Teresa's family at the time this case happened, because why would they doubt law enforcement? They have no reason to doubt that. But since then, everything that's come out, if I was her family, I would have to look at it and have doubt. At the very least, in Stephen's case, there's reasonable doubt. Bob says, did Stephen ever receive his wrongly convicted settlement from his first incarceration? Yeah, he had to settle where he to pay for lawyers. So that's done and gone now. Sharky, and it just now booted up. Was it Blaine who stated he had seen Bobby driving the RAV on a major road? Yes. That's damning itself. Yes. Amanda says, Stephen listens to country music. He says it himself. He feels like he's on Truman Show and knows they're watching his every move. Kelly says, where is Bobby now? Shocking. Disgusting to think he is free. Well, Kelly, Bryce and I recently, we went to Manitowoc in November, and I went to Bobby's house. And so there are pictures here on Stephen Avery Project that Bobby saw me in front of his house, and he started walking towards my car, and he did not look happy. So Bobby lives in Mishicot. He's like 5 minutes from his mom. Amanda asks, who's Blaine? Blaine is one of the Dassey brothers. So Blaine was the one coming home that day on the school bus with Brendan. And that Blaine left to go trick-or-treating that day. Okay, and there was Amanda answering a question. So I'll go back to where I was reading. We're on 37 of 57. Moreover, the circuit court failed to consider the motive evidence, although not conclusive, in conjunction with Mr. Avery's new evidence, which establishes a direct connection between Bobby and the crime. Mr. Avery offered his motive evidence in conjunction with evidence of Bobby's opportunity and direct connection to Ms. Halbach's murder and the framing of Mr. Avery. Evidence of motive that would be admissible against a third party, were that third party the defendant, is therefore admissible when offered by a defendant in conjunction with evidence of that third party's opportunity and direct connection. In rehashing the weight of Mr. Avery's prior evidence of motive contained on the Valley CD, which this court already assessed was not sufficient in and of itself, but could be relevant if Mr. Avery could also show Mr. Dassey's direct connection, and there's a footnote. The footnote says, this court stated, quote, the evidence, and then in brackets, Sawinski's evidence, presented might supply the missing is bolded and italicized, supply the missing direct connection, unquote. All right, back up here. The circuit court evaluated the CD evidence in isolation contrary to this court's prior directive in remanding the case, see Wilson, where the Wisconsin Supreme Court determined that the, quote, strength and proof, unquote, of one of the prongs may, quote, affect the evaluation of the other prongs, unquote. Here, Mr. Avery's powerful direct connection evidence certainly affects the evaluation of the other prongs because it provides evidence supporting all three prongs of the Denny test. For example, even if the motive for Ms. Halbach's murder was not sexual, as law enforcement believed, the Sawinski evidence offers evidence that the motive could have been a robbery, and that's italicized, or not italicized, footnote, and the footnote says, many things were missing from Ms. Halbach's RAV4 that should have been present in the vehicle, such as Ms. Halbach's purse, wallet, money, which she had been paid that day because she was paid in cash, driver's license, schedules, receipts, maps, Toyota Master Key, house key, and other items related to her activities with AutoTrader or her hustle shots. There has never been proof previously that a third party had possession of the vehicle which contained these items. Importantly, Ms. Halbach's vehicle itself had been stolen. All right. Somebody's messaging me, asking me, have you gone live? And I've missed it. I'm live now. Why does my phone change my words? Okay. Sharky says, was there any mention of bloody in the hand basin of Avery's trailer by law enforcement during any searches? I dare say no. It's convenient for them to leave this out of any discovery or report. I don't know if they had it listed. Maybe somebody who remembers stuff better than I can answer that for you. The circuit court's findings that Mr. Avery had not established the motive element is at odds with Wisconsin case law. Wisconsin cases that discuss the motive element of their Denny analysis show that the standard for fulfilling the motive element of Denny is not overly burdensome, especially when there is strong evidence of a third-party perpetrator's direct connection to the crime. For example, State versus Ramsey is a case in which very weak evidence of motive against a third party was presented by the defendant. However, the appellate court found there was strong evidence of a direct connection, and thus it found plausible reasons for the third party to commit the crime. There you are, Natalie. Adrian, since there's now a new judge, I'm hopeful. Knock on wood. Amanda, they're talking about the blood that Stephen left on his sink. If the state had logged that into evidence at all, had noted that there were... Well, no, wait, they wouldn't have seen that because Stephen said he knew himself the next day it was gone. Right? That Stephen had done was really quick, and he was going to Home Depot or whatever that night, and then the so he didn't clean it up that night, and then the next morning he had planned to clean it up and it was gone. So state never saw that blood. In Ramsey, the victim was found stabbed at home. The 911 caller told police that the victim had been staying at her sister's home to hide from the defendant. The defendant had been in a relationship with the victim for over 11 years, and they had 2 children together. They had a history of domestic violence. Officers found the defendant, and the defendant admitted stabbing the victim twice. The victim's best friend told police that the day before the stabbing, the victim told the defendant that she was going to leave him. After fingernail clippings from the victim revealed another man's DNA, the defendant brought forth a Denny motion, arguing that a potential third-party perpetrator, 1, was a convicted criminal, 2, lived near the crime scene, and 3, his DNA was present at the scene and is unexplained. The defendant alleged 2 possible motives for the third-party perpetrator: irrational rage and antisocial behavior and or sexual gratification. The defendant argued that it was possible that the third party had no rational motive. Thus, the defendant presented evidence of a general motive that was not directed at the particular victim. Okay. In Ramsey, the circuit court found that the defendant had failed to establish the third party's motive and denied the motion. However, the appellate court reversed the circuit court's ruling, stating, quote, "We conclude that when considered under the applicable law regarding motive, and with the opportunity, evidence, and the strong direct connection evidence, Ramsey has presented plausible reasons for the third party to commit the crime," unquote. The appellate court found that, quote, "under the totality of the circumstances, the evidence suggests a third-party perpetrator actually committed the crime," unquote, emphasizing that suggests is a rather broad term, close quote. I'm still loving my Candy Crush chair. It's such a comfortable chair. I'm trying to read Amanda's comment here. Oh, where'd it go? Amanda says, "I didn't watch Making a Murderer, but I heard Stephen's interview when they accused him. That's all I needed to hear. I am beginning to think I'm the only one who thinks the cops aren't just framing Stephen, but they did and burned her as well. Or get blood on the bullet that was fired from the gun the police had in their possession." There's plenty of people who think that the police did it. I don't think the police did it, but I think the police did things so Stephen would be found guilty. Sharky says, "So Stephen and only those who had access to the trailer when Stephen wasn't there would have known about blood in the sink. Shame that likely other person needs to keep quiet about finding the blood. It's a key piece of evidence." Yeah, so Stephen, hold on. Stephen said the cut on his finger that he got in Crivets, putting the tin roof on his dad's place, it was obvious to Bobby, that he saw the finger. So I have another finger for Bobby. Here, Mr. Avery has presented far more evidence than is even required to suggest that a third party actually committed the crime. The circuit court's failure to consider the Denny prongs in the aggregate and its erroneous imposition of a burden of substantial certainty on Mr. Avery's motive evidence results in a fatally flawed opinion on the law and the facts. Yeah, sorry it's so late there for y'all in the UK. It was, as soon as I got it, I was coming live. Good night, Adrian. Number 3, opportunity element of Denny. In regard to the opportunity element of Denny, The circuit court stated in its opinion that, quote, even if the defendant had met the burden with respect to the motive element of the Denny test, he has not met the burden with respect to the element of opportunity under the same test, unquote. It is undisputed that Bobby was on the Avery family property when Ms. Halbach was there, and before and after she was reported missing. Normally, even proximity to the murder is sufficient to show opportunity. However, the circuit court improperly imposed a burden on Mr. Avery to prove that Bobby had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in order to satisfy the opportunity element of Denny. The circuit court stated State versus Wilson for its own finding that a Mr. Avery has to prove that the potential third party had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in the manner alleged. However, in reality, the principle came from the Kansas Court of Appeals case that the state cited in its response brief, State versus Kreider. Even if the principle from the Kansas case were to somehow apply to Wisconsin, the facts of Kreider are completely inopposite. I don't know that word, but it's INA, inapposite, to those in Mr. Avery's case. In Kreider, the defendant's proffered evidence of a potential third-party perpetrator consisted of alleging a potential motive for the victim's son-in-law to kill her, in that the son-in-law's wife would benefit from the inheritance and that the son-in-law could have had the opportunity to get defendant's hair from headgear and blood from used bandages to later plant at the crime scene while staying there overnight because he worked as a first aid officer at the defendant's work. The court found that the evidence did not effectively connect the third party to the crime, stating, quote, this evidence is nothing more than mere speculation and conjecture and does not connect the third party to the crime, and therefore the district court did not err in excluding it, unquote. That's what I thought, Alyssa. Rather than considering that this principle came from a Kansas case, not a Wisconsin one, the circuit court imposed a burden on Mr. Avery to demonstrate that Bobby had the scientific knowledge to plant evidence. The facts of Wilson are completely, and here's that word again, inopposite to Mr. Avery's case. So, must be a lawyer word. In Wilson, multiple eyewitnesses identified the defendant as a shooter. The defense attempted to argue that someone else was the shooter by proffering evidence in an alleged potential third-party perpetrator. However, the potential third-party perpetrator was completely unknown because the defense's theory was that a hitman was hired by the man in the car with the victim to kill the victim, and then the hitman shot the victim. The Wilson court found that there was no evidence showing that the man in the car with the victim had the opportunity to hire a hitman in the brief amount of time he was in the car with the victim before she was shot by someone else. The defense failed to present any evidence of contacts, influences, or finances used to hire a hitman to corroborate its hypothetical theory that the potential third-party perpetrator was some unidentified hitman. Thus, the Wilson court found that, quote, Wilson's proffer failed to demonstrate that these alleged assassins were anything but purely hypothetical people, unquote. Paula. Hello, Paula. Hi. Hey, Paula. Says, to me, the sweaty Kratz and the two investigators went out of their way to conceal, deflect, and hide evidence that pointed to Bobby. Sweaty Kratz referred to the Veli taps as, quote, from Brendan's computer. Sorry, it keeps going up and I have to keep finding it again. The prosecutor turned over the Veli tapes that were saved with unique, inaccessible format. And if I remember correctly, didn't Fackbender keep copies of the accessible Veli tapes in his possession for years? The defense didn't know they existed during Avery's defense? Yep. And thank you, Alyssa, saying inapposite. Inapposite means out of place. Okay. Importantly, Wilson is not a case about planting evidence or framing. Wilson specifically stated that this type of theory only requires a showing of access to frame, stating the following, quote, if the defense theory is that a third party framed the defendant, then the defense might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up, unquote. However, the circuit court erroneously reasoned that pursuant to Wilson, Mr. Avery must prove that Bobby had the scientific knowledge to recognize the significance of each piece of forensic evidence supposedly planted by him, let alone establish that he had the skill to plant that evidence in a way that would stand up to a scientific scrutiny by professional crime scene analysts, unquote. This is not the standard for showing a third party framed the defendant. Evidence that the third party had access to the items used in the frame-up is sufficient pursuant to Wilson. Ultimately, the circuit court imposed upon Mr. Avery a standard for satisfying the opportunity element of Denny that has never before been applied in any Wisconsin case. State versus Volbrecht is a case in which the evidence of connection and motive carried the strength of the opportunity evidence. The trial court granted the defendant a new trial, and the appellant court affirmed. Although the evidence of the third party's opportunity only theoretically put the third party in the geographic area of the murder of the victim, the appellate court focused on the strength of the evidence of motive and direct connection rather than imposing any higher burden to show opportunity, as the circuit court in Mr. Avery's case did. The facts of Volbrecht are similar to those in Mr. Avery's case, where in both cases the defendants were convicted based in large part on completely circumstantial evidence. In Volbrecht, the defendant was convicted of a first-degree murder and first-degree sexual assault after a woman who had been shot in the back was found in a wooded area, naked and hanging from a tree by tire chains. The defendant had been with the victim the day before she was reported missing. He told police that he was dropped off by her, but detectives spoke to several people who knew the defendant and were in the area where he claimed the victim dropped him off, and none of them saw the defendant in the area. Police interviewed a witness who identified the defendant as the person the witness saw near the area where the victim's body was found on the day she was reported missing. Further, the defendant's hairdresser told police that the defendant talked to her about the murder investigation and told her that, quote, I didn't do it, and if I did, I don't remember doing it, unquote. A witness who lived near the area where the victim was found testified that he woke up and heard shots around 2:50 a.m. and the sounds of a car dragging, which then stopped. He heard it start up again 20 minutes later. His testimony was used to establish that the victim was murdered before 3:30 a.m., the time which the defendant estimated he had parted ways with the victim. Let me go back to see what you guys have been posting. On what planet does law enforcement discover illegal content on one's computer and yet doesn't file a report, open an investigation? I suppose being a key witness for another crime provides you a get-out clause. Yep. And Amanda says, yes, and Zellner is still not able to see the RAV. I don't get why they don't have to turn over the car. I mean, I'm sure they don't have it anymore, but... Okay. 20 years after his conviction, the defendant filed a Wisconsin statute motion for a new trial based on newly discovered evidence of a third-party perpetrator who had been convicted of a similar killing only 6 weeks later. The new evidence stemmed from the post-trial discovery of police reports, including information that a search of the third party's residence uncovered a revolver and books involving rape, chains and torture, notes about the third party's statements to co-workers about tying girls up, abusing them, and getting rid of them, and statements to inmates that the third party liked to chain and burn women. The state took issue with the opportunity prong of Denny being satisfied, noting that the third party lived 30 miles away from where the victim was found and also had killed the other victim 30 miles away. It argued that opportunity evidence must be more than just the theoretical possibility of the third party committing the crime. However, the appellate court rejected this argument and found that, quote, the record reflects that the post-conviction court's determination as to opportunity was made in light of the evidence presented as to motive and direct connection. We agree with the defendant that the facts give meaning to other facts and that the significance of the third party's opportunity to commit the crime depends on his alleged motive and direct connection, unquote. Natalie says, does anyone know where Thomas Sawinski, the newspaper delivery guy, is? For me, he is the key witness and needs to be protected and live long enough to testify at any new trial. I can't remember. For some reason, both Colorado and Arizona are in my head. But I know in Arizona is like where Lank retired to, so maybe that's why Arizona's in my head. But Sawinski does not live in Wisconsin. In Mr. Avery's case, the opportunity element has already been decided previously by the courts. According to Mr. Avery's trial court, Mr. Avery's trial defense counsel already established that Bobby had the opportunity to commit the murder of Ms. Halbach because of his presence on the property at the time Ms. Halbach was there. Sorry, I scrolled on the wrong page. Moreover, Mr. Avery's new evidence could not present a better case for showing a third party's access and, accordingly, evidence of a frame-up. The Sawinski evidence greatly strengthens Mr. Avery's evidence that Bobby had the opportunity to commit Ms. Halbach's murder because it shows that Bobby was in possession of, typo, it says Mr. Halbach's vehicle, Ms. Halbach's vehicle, where her murder likely occurred. He had access to Ms. Halbach's vehicle and all of the evidence used to convict Mr. Avery of her murder. Quote, if the defense theory is that a third party framed the defendant, then the defense might is italicized, might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up, unquote. Correctly applying Wilson, Mr. Avery has not only shown Mr. Dassey's opportunity because of his proximity to the murder, but also because he had access to the items used in the frame-up. The defense theory of a third party's involvement will guide the relevance analysis of opportunity evidence in a Denny case. It is not the circuit court's theory that guides this analysis. We're going on to page 46 of 57. But I also want to remind everybody, too, the reason Sawinski, to me, is so powerful is he's not somebody who watched Making a Murderer and just wanted his 15 minutes of fame and came up with something for and then comes forward to Kathleen Zellner and said, I saw this. He reported it back before this case was famous, before anybody knew anything. So to me, that shows this guy is telling the truth, because why would he come forward on November 5th? What's in it for him? Nothing. And I'm going to guess most people, I don't want to get involved, are not going to just make something up of, I saw this car. I don't know Thomas Sawinski, but I'm just going to say, I think most people are not wanting to assert themselves into a case with because this would be a crazy lie on his behalf to just come up with out of the blue of why would he even say he saw Bobby Dassey? nobody's talking about Bobby Dassey at that you know what I mean? It's just so he came forward back that when this crime happened, not today. So he is completely believable in my opinion. Rather than accepting this, the circuit court found that Bobby needed some kind of expert scientific knowledge to plant the evidence that he had access to in the vehicle. However, there is no scientific knowledge necessary to know that planting someone else's blood in the vehicle of a woman that went missing would be incriminating. Common sense would suffice. The circuit court did not explain what special skills it took to shoot Ms. Halbach in the head that Bobby lacked. All that was required was to pull the trigger. Bobby was a skilled deer hunter with a 22 rifle. He had the same exact rifle that was at hanging in Stephen's bedroom. He had obviously pulled many triggers. In terms of planting the evidence with the blood, the only skill that would be required is taking a wet sponge and removing Mr. Avery's blood from his sink and dripping 1 to 2 milliliters into the RAV4 and then applying it to the dashboard with a household item such as a Q-tip. I guess you should say cotton swab. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31, 2005, re-bled on November 3, 2005, and dripped blood in his bathroom sink and on the bathroom floor. Mr. Avery told law enforcement and his trial defense counsel as he was leaving his property on November 3, 2005, and exiting onto Highway 147, he observed taillights of a vehicle close to his trailer. Mr. Avery told trial defense counsel he noticed the blood had been removed from his sink when he entered the bathroom early in the morning on November 4. Now, this is the only thing that I part ways with Kathleen on. I do not think that Bobby Dassey planted the blood. I do believe Manitowoc did. But that's not to say that Bobby didn't or couldn't. Okay, so if he was searching all those other items, and now remember, his mom had that computer gutted, and also or wanted to have that computer gutted, or did, or and that there is stuff that has not been, stuff was deleted and was not found again. So who's to say that Bobby was not searching how to plant blood? Well, many of the Avery family have that low IQ. Stephen has it. Barb has it. Brendan has it. Bobby does not. So I'm not saying the guy's a genius, but he's capable of searching it and doing it. I just think everything lines up more that Manitowoc planted the bullet, the key, the blood. Bullet, key, blood. The bullet fragment found on Mr. Avery's property simply had to be rubbed in Ms. Halbach's blood or on her skin cells, both of which her murderer had access to before her body was burned. This court determined, quote, the state did not argue that this specific bullet entered Halbach's skull or killed her, unquote. And there were no bone fragments on the bullet. It is undisputed that there were bullets all over Mr. Avery's property from Raleigh Johnson shooting gopher holes with his .22 rifle, as well as Jody Stokowski firing it. This was the gun that fired the bullet that was found on Avery's garage floor with Ms. Halbach's DNA on it. No skill was required to plant the electronic devices in Mr. Avery's burn barrel. The fact that there were burn barrels at the Dassey property, 4 in total, one of which contained human bones, shows that the Dasseys, which includes Bobby, were proficient in burning material in the burn barrel. Part of the circuit court's interpretation of Mr. Avery's guilt of Mr. Avery's guilt is based on another factual error. It's believed that all of Ms. Halbach's bones were found in the Avery burn barrel. They were not. They were found in the Dassey burn barrel. Dr. Eisenberg claimed that when she opened the container of bones from the Dassey burn barrel, she got a, quote, waft of flammable liquid or fluid, unquote, but did not smell burned rubber from tires, which the state claimed was the accelerant Mr. Avery used. This evidence suggests Ms. Halbach's body was burned in the Dassey burn barrel and dumped in Mr. Avery's fire pit. Common sense suggests that Mr. Avery would not have been planting evidence to incriminate himself. The circuit court erroneously stated that Mr. Avery argued that Bobby planted the key to the victim's RAV4 in Mr. Avery's trailer between November 3 and November 5. There was no such argument made. Bobby would have had the key when he planted Ms. Halbach's vehicle on November 5 because it is undisputed the RAV4 was locked when it was discovered. So whoever left the vehicle on the Avery property necessarily had the key and locked the vehicle. Bobby had access to Mr. Avery's unlocked trailer from early Saturday morning, November 5, until shortly before noon, when the vehicle was located on the Avery property was secured by law enforcement. Mr. Avery and his mother left for their Crivets cottage around early Saturday morning. Which again, if Stephen did this and left the RAV4 close to the car crusher because I just need everybody to be gone so I can crush this car, but then he goes with everybody and isn't taking the opportunity when his entire family, except for Earl, because Earl was the one scheduled to work that Saturday, but that's only, like, they're only open till noon, and then Earl was going to be going up to Crivets. So instead of taking that up, and Earl didn't live on Avery property too, so when he was done with work, he would be leaving. And so Stephen would have Avery Salvage all to himself that day. He went to Crivets. No sense. According to the circuit court criteria, Mr. Avery was even less qualified to commit the murder than Bobby by way of comparison. In terms of his education, he was less educated than Bobby, never having graduated from high school. He was less skilled than Bobby because he never held a job because of his wrongful conviction, whereas Bobby was employed as a third shift worker at a furniture factory. During all the years Mr. Avery was incarcerated for his first wrongful conviction, Bobby had been honing his skills in stalking, hunting, killing, burning, and dismembering game. After misapplying Wilson, the circuit court erroneously presupposed that the forensic evidence against Mr. Avery stood up to scientific scrutiny in Mr. Avery's trial. Mr. Avery's defense team never presented the required experts to attack the scientific evidence. Mr. Avery, in his second post-conviction motion, presented voluminous evidence from numerous experts that the forensic evidence which was used to convict Mr. Avery was vulnerable to being discredited if the defense actually presented all of the experts that trial defense counsel failed to present, such as DNA, trace, blood spatter, fire, forensic pathologists, and ballistic experts. This court determined, quote, certainly these conclusions tend to support Avery's general theory that he was framed and their presentation may have been useful at trial, unquote, but concluded that Avery's experts had failed to show, quote, how its introduction at trial could reasonably have led to a different outcome, unquote. Now, this court has the direct link between a third-party suspect and the forensic evidence. This court can consider Mr. Avery's forensic expert opinions in light of the identification of a specific third-party suspect in determining if this evidence could reasonably have led to a different outcome. For example, Mr. Avery's blood spatter expert described the blood pattern distribution in the vehicle as being inconsistent as coming from an active bleeder, as the state claimed. Knowing Bobby had access to Mr. Avery's sink with blood in it and how simple it would be to selectively drip the blood in the vehicle, this court should reconsider the blood spatters expert affidavit. Mr. Avery's DNA expert described that in the controlled experiments he conducted with Mr. Avery holding the key for 12 minutes, there was 10 times less DNA deposited on the exemplar key than what was present from Mr. Avery on the vehicle key found in Mr. Avery's bedroom. I should say found. The expert suggested that if the DNA on this key was enhanced, some personal item of Mr. Avery's was used for this purpose, such as a toothbrush or cigarette butt. Cigarette butt? Stephen didn't smoke. Mr. Avery previously presented an affidavit that he noticed his toothbrush was missing in the law enforcement photos taken from the bathroom in his trailer. In regard to the hood latch, Mr. Avery is not abandoning his theory that the illegally collected groin swabs taken from Mr. Avery were substituted for the hood latch swabs when they were delivered to the Wisconsin Crime Laboratory. However, for purpose of demonstrating that Bobby had the skill necessary to plant DNA on both the hood latch and Ms. Halbach's key, Mr. Avery asserts that Mr. Avery's toothbrush could have been rubbed on both. Bobby had access to the trailer where his toothbrush resided prior to disappearing. My theories on these things right here. I don't know where I got this from. But I could have sworn at some point during this case that one of the lab people, they had taken Stephen's Grand Am and they had brought that to the same garage that they had the RAV4, and that a lab person did not change their gloves in going from the Grand Am to the hood latch. And so that's how they then transferred Stephen DNA onto the hood latch. And so in that instance, it's not to frame Stephen, it's a dummy in the lab. And I've just known that for years now, but I don't recall where that comes from. And then from the key, I feel like that was rubbed on his slippers that were right there. Sure, there's plenty of Stephen's DNA in the slippers. 4. Direct connection element of Denny. No bright lines can be drawn as to what constitutes a third party's direct connection to a crime. Rather, circuit courts must assess the proffered evidence in conjunction, that's italicized and bold, with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests, bold and italicized, that a third party perpetrator, and now this is underlined, actually committed the crime. In its opinion, the circuit court argued, quote, the Sawinski affidavit, taken as true for the purpose of this motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself, unquote. Amanda, that's something I've said over and over forever. His finger wouldn't touch the dash to make that squiggly line that is clearly from a cotton swab. You're not supposed to say Q-tip because that's a brand name. So why would his blood be there? It's so dumb. But his blood's there, but his fingerprints aren't. Wearing gloves, not wearing gloves. If he's wearing gloves, then why is it a squiggly like this? That's not a drip. And then Kathleen also pointed out previously about the blood that's on the front carpet, that's not blood that dripped, that would have then soaked into the carpet. These were flakes that were at the top of the carpet fibers. Um, in its opinion, the circuit court argued, quote, the Sawinski affidavit, taken as true for the purpose of this motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself, unquote. Then the circuit court highlighted the fact that, quote, Mr. Sawinski's affidavit does not mean seeing to the victim's car, does not mention seeing Bobby with the key to the victim's car, unquote. It ignored the fact that when Ms. Halbach's vehicle was found by law enforcement and volunteer searchers, it was locked. Clearly, Bobby had the key to the vehicle. Further, the circuit court ignored that all the forensic evidence used to convict Avery was discovered, bold and italicized, after Bobby was seen moving Ms. Halbach's vehicle onto the Avery property. Wah wah. Sorry, Bryce. What? There was something I wanted to say there. Now I can't remember. All right, let's continue. We're moving on to page 51 of 57. In State versus Williams, the appellate court found a direct connection between the perpetrator of the murder and the fact that he had possession of the victim's vehicle several days after her murder. Specifically, the court explained, we agree with the state that from all of these circumstances, now this is bolded and italicized, under a common sense, non-technical approach, a reasonable police officer would draw the reasonable inference that both Williams and Armstead had been in possession of Brown's stolen car. There was probable cause to believe that both Williams and Armstead probably had committed a crime involving the murder victim's stolen car. Applying this common sense approach here, the Sawinski evidence provides the direct connection, that is, Bobby being witnessed in possession of Ms. Halbach's vehicle. I think that's what I was going to say there. Bobby's their star witness. And he didn't say anything about pushing the car there. Yeah, he doesn't have to incriminate himself. But this again, then, if you're going to state, okay, we'll just state as fact that Bobby was pushing that car, then it's everything he testified to can't be believed. Applying this common sense approach here, the Sawinski evidence provides the direct connection, that is, Bobby being witnessed in possession of Ms. Halbach's vehicle, to Bobby having committed the murder of Ms. Halbach and planting the evidence to frame Mr. Avery. There's a footnote, and I didn't see it. The footnote says Mr. Avery realizes that this case existed 2 months before it was found to not have precedential value. However, it is noteworthy for employing a common sense approach that possession of a murder victim's stolen car means the thieves probably committed the murder. Okay, rather than recognizing the significance of evidence that Bobby had possession of and thus access to Ms. Halbach's vehicle, the circuit court required Mr. Sawinski to see Bobby in possession of the electronics inside Ms. Halbach's vehicle. However, a reasonable inference can easily be made that because the electronics had not yet been found by law enforcement when Bobby was seen by Mr. Sawinski with Ms. Halbach's vehicle, they were still inside the vehicle. Now we're on page 52 of 57. In State versus Knapp, the Wisconsin Supreme Court found that in light of Denny and Chambers, hearsay evidence implicating a potential third party in the victim's murder was properly admitted because it established the requisite direct connection pursuant to Denny. In Knapp, The defendant was the last person seen with the victim as they went out together that night. During trial, the defendant sought to introduce evidence of other potential suspects, including the victim's husband, Brunner, and the woman he was having an affair with, Mass, on the night that the victim was murdered. Specifically, the defense sought to introduce hearsay evidence through the testimony of a witness, Farrell, who was close friends with a man named Borchardt, whom Mass had lived with at the time but had since passed away. Through Farrell, the defense sought to introduce statements made to him by Borchardt regarding his observations of Mass's behavior right after the homicide and his observations of Brunner's truck at the Mass's residence after the murder. The Wisconsin Supreme Court found that the third party of the Denny analysis, the connection, was at issue. However, ultimately, it found that the evidence supplied the missing direct connection using the following reasoning. Quote, the evidence at issue in the Knapp case connects the third parties, Brunner and Mass, to the crime in a number of ways. One, it establishes that Brunner lied to investigators about his whereabouts at the time of the murder. Two, Mass was with Brunner at the time his wife was murdered, and Mass was observed a short time after Mrs. Brunner's death, carrying a paper bag and getting into Brunner's waiting truck. And three, most importantly, the evidence puts Brunner in Watertown in relative proximity to the Alexa is talking throughout my entire house right now. To the location where the homicide occurred and near the time of the murder. Based upon that information, we hold that the circuit court correctly determined that the evidence established Brunner's motive, opportunity, and connection to the crime. Further, we hold that this circuit court applied the proper legal standard and appropriately exercised its discretion in admitting this evidence under Denny. The court found that based upon these three inferences listed above, the hearsay evidence established Brunner's connection to the crime and also fulfilled the motive and opportunity prongs of Denny, which it did not even dispute. If the same reasoning were applied to Mr. Avery's case, the circuit court would have found far stronger evidence of a direct connection to allow the defense to present Bobby as a potential third-party suspect pursuant to Denny. At a bare minimum, the Sawinski evidence connects Bobby to Ms. Halbach's murder in all the same ways that the hearsay evidence did to the third party in the Knapp case. 1. It establishes that Bobby lied to investigators about his whereabouts during times relevant to determining Ms. Halbach's murder. In parentheses, noting, of course, that the exact time of Ms. Halbach's murder is not known. Unquote, or unparentheses, unbracket, whatever you want to call it. 2. Like Mass, who was observed carrying a paper bag after the murder, which the Wisconsin Supreme Court found was material, Bobby was seen with the victim's vehicle after Ms. Halbach's murder. And 3. The evidence certainly put Bobby in close proximity to the location where the homicide is alleged to have occurred, and that, combined with evidence showing that Bobby, according to his own testimony, was one of the last people to see Ms. Halbach alive, would have satisfied Denny had the circuit court applied only the reasoning of Knapp. The Supreme Court of Wisconsin offers an illustration to exemplify. Oh, my throat. I've been talking. Oh, my God. I've been on for over 2 hours. Ugh. The Supreme Court of Wisconsin offers an illustration to exemplify what type of evidence can show a direct connection to a degree of certainty required by the legitimate tendency test to admit evidence regarding a third-party suspect. By illustration, where it is shown that a third person not only had the motive and opportunity to commit the crime, but also was placed in such proximity to the crime as to show he may have been the guilty party, the evidence is admissible. Even if the circuit court's numerous factual errors were correct and Brendan Dassey was, quote, directly linked by forensic evidence to this murder, unquote, and his confession was admissible evidence against Mr. Avery, this still does not allow the circuit court to dismiss the powerful evidence of a third party's direct connection to the murder. Overwhelming evidence against the defendant may not serve as the basis for excluding evidence of a third party's opportunity or direct connection to the crime. Quote, by evaluating the strength of only one party's evidence, no logical conclusion can be reached regarding the strength of contrary evidence offered by the other side or rebut or cast doubt. Unquote. Conclusion. We're almost done. We're in the home stretch here. For the reasons stated herein, Mr. Avery respectfully requests that this court grant him one of the following alternative remedies. 1. Reverse the orders denying post-conviction relief and grant an evidentiary hearing. 2. Reverse the judgments of conviction and the orders denying post-conviction relief and remand for a new trial. And 3. Grant any other relief this court deems appropriated. Dates, typo, this 12th day of January 2024. Electronically signed by Kathleen T. Zellner and Stephen G. Richards. Certificate of compliance. That is the entire thing. Let me get the link to where I was reading that from. And where can I comment here? Here's the link if it lets me post it. So if people want to read that for themselves. So that's that. So now we wait for the state's response. I don't know if they have 30 days, 60 days, 90 days. I don't know if the judge, how long they have till they have to rule. I don't know. I'll see if I can find out from an attorney or a judge, or maybe if Kathleen will tell me. So, but I've now been on for 2 hours and 21 minutes. So I'm going to go now and stop talking. Thank you, everybody who joined us live, and those of you who will be joining us on Memorex. As soon as we get any of the responses, when those happen, we go live. So you have to like and follow the page, and hopefully you get notified. Usually, Christopher, my friend and moderator, likes me to give him a heads up, and then he posts everything everywhere to tell people, but I just jumped on this because it came in and I knew it was big. So, all right, I am out. Thank you again, everybody. Stephen Avery is innocent, and investigation continues.